The regulatory references regime has thrown up many practical problems for financial services firms since it came into force on 7th of March 2017. In this podcast today, I'm going to be talking about the obligations on firms to seek and provide regulatory references, the type of information that must be provided, and our experience of what impact a negative reference is having in employment tribunal litigation. It is worth reminding ourselves from the outset that a distinction must first be made between a firm that is fully covered by the regulatory references regime, commonly referred to as a full scope firm, and other firms regulated by the FCA and PRA who have more limited obligations under this regime. Full scope firms include banks, building societies, credit unions and PRA regulated firms, including insurers subject to the senior insurance managers regime. Under the proposed rules for the extension of the senior managers and certification regime, the regulatory reference rules will be rolled out to all regulated firms so that all regulated firms, insurers and reinsurers will become full scope firms. This will be in December 2018 for the insurance sector and early 2019 for other financial services firms. Another point to note is the definition of employee for the purposes of a regulatory reference is very wide and includes employees, workers and self-employed contractors. This has in the past raised concerns about ensuring the fitness and propriety of persons undertaking certification functions who are employed by their own limited company or seconded from a professional services firm and therefore not subject to the disciplinary procedures of the entity to which they provide services. However, the regulators, whilst noting these concerns, have insisted that regulated firms must ensure the fitness and propriety of senior manager and certified staff, and regulatory references are a key tool in achieving this. The regulatory references regime requires a full scope firm applying for regulatory approval for a senior manager or issuing a certificate for a certified employee to first request a regulatory reference from all previous employers in the last 6 years, even if the previous employer is outside the financial services sector or is overseas. The information required is set out in the regulator's mandatory template. A full scope firm that provides the reference must disclose all the required information going back 6 years from the date of the reference request. It also has an obligation to update a reference where new information arises that may cause it to have written the reference differently. This requirement to update will require extensive tracking and recording of disciplinary action with respect to conduct rule breaches and other relevant information. The FCA considers that full scope firms should be able to provide a regulatory reference within 6 weeks, which means that such firms should have effective record keeping systems in place. One way to do this is to have a running draft reference on file, which is kept regularly updated. Another problem area is whether to investigate potential breaches after the employee has left. If a firm does decide to investigate a former employee, the fairness of its processes and any subsequent reference will be compromised unless the departing employee has an opportunity to comment on the allegations. Given the potential impact on future career and historic nature of the allegations, such investigations are likely to become very protracted. Firms outside the financial services sector cannot be obliged to provide a regulatory reference, but hiring full scope firms should still take reasonable steps to obtain one by writing to that firm. The information required from a full scope firm is far more detailed than other regulated firms and must include all the information set out in the regulator's mandatory template. A full scope firm must respond to each question explicitly, and if it has no information, it must state this. The Any Other Relevant Information section throws up the most issues when completing the template. Firms are left to make a judgment on a case-by-case basis, having regard to their general duty to give fair and accurate references, with obligations to both the ex-employee and recipient of the reference. These duties include the common law duty of care, tortious negligent misstatement, and data protection requirements. The disclosure of the mandatory information and any other relevant information means that employees can no longer jump ship and hope to leave a past record behind them. The Any Other Relevant Information section means that firms can disclose disciplinary investigations that were started but not concluded because the employee left before a disciplinary hearing. The impact of such disclosures on the employee's careers in the financial services sector is extremely significant and means employees in this sector will be more likely to challenge negative regulatory references. Equally, if a firm withholds information, it may open itself up to challenge from the new employer and the regulator's unwanted interest. Probably the best approach is to offer the individual the right to comment on allegations in the reference. We at Evershed Sutherland are already starting to see the impact of a negative reference being reflected in the tribunal awards for unfair dismissal, since a regulatory reference that refers to a suspected misconduct will seriously hamper that individual's chances of mitigating their losses. In our experience of handling litigation on behalf of our clients, where a dismissal is found by the tribunal to be unfair, tribunals have been awarding more compensation than we think they would have done previously to reflect the fact that the individual is going to find it harder to obtain another regulated role in the financial services profession. Firms may find themselves having to pay the maximum compensatory award where there is an unfair dismissal finding. Firms must therefore be careful to observe a fair dismissal process to minimise the risk of a successful claim. It is also worth remembering that firms can no longer find a way out of litigation by agreeing a favourable or neutral regulatory reference in settlement agreements, since the rules prevent any agreement or arrangement that limits an ex-employer's ability to disclose relevant information. However, again in our experience, so far tribunals are reluctant to get involved in the issue of a regulatory reference or order the firm amend its reference even if the dismissal is found to be unfair. This is a matter between the individual and their ex-employer, subject always to any breach of common law or other duties. If the firm has reached reasonable conclusions about an individual's conduct which it refers to in the reference, it is entitled to continue to reference this, subject to referring to the tribunal's finding that the dismissal was subsequently found to be unfair, or by appending the judgment to the reference.